Okay, great. Good afternoon, Anna. It is wonderful to have you join me to have a somewhat brief discussion about your forthcoming book. It should be out next month. You must be very excited. Is this the point at which we get to see the cover of your book by your? Is there an image that you can show us?
I do have the image. So this is the cover, which I'm really excited about. I think it is
an amazing cover. So it's Vice Patrol, Cops, Courts, and the Struggle Over Urban Gay Life Before Stonewall. And this is going to be released next month in May.
It is, yes.
Available for purchase. You must be very excited.
I am. It's, obviously it's been so many years working on this project in some capacity. So I'm excited to have it out.
And so how many years has it been?
Well, it's, my journey has been a little disrupted by law. So I essentially, I went to law school partway through the PhD, and I worked a little on the project when I was in law school. And then I finished it while I was clerking. And then when I went on the legal job market, I just set it aside and I focused on some other projects, which was incredibly useful because I just had 2 years when I really wasn't thinking about it at all. And then I was able to come back and see it with fresh eyes. So in all, I think I picked the topic maybe either 10 years ago, maybe 11 years ago. But then, between doing law school for a few years and taking some time off, I wasn't working on it the entire time. But it's, it's certainly, it's been in the back of my brain for a really long time. It's changed a lot, of course, over those years too.
Absolutely, it has to, because you changed.
Yes,
you have
right.
changed a lot over that period of time and grown in so many ways, I'm sure. So why don't you, Anna, tell us about how you came to this project? In Vice Patrol, what you're trying to do is to explain or describe the shifting priorities, investigative tactics, and legal disputes that shape the gay world's confrontations with the law, with the state. And you highlight here the daily realities of urban policing in order to bring the story to life. What led you to conduct this story well over 12 years ago, or at least the beginning
right
around this? Yeah, what led to this project?
Right. So, I came to graduate school knowing that I wanted to work in the history of sexuality. That's just something that I had studied as an undergrad. My favorite books of history that really led me turned to history from more of the literary based work I was doing before were all histories of sexuality. So I knew that I wanted to work on something in that space. And then once I got to Harvard, there were really two developments that put me on the path to this book. So one, I was really lucky to be at an institution with this massive library. And I found a number of rich and somewhat rare documents in the library. Those included policing manuals that really showcased how police institutions were thinking about vice enforcement, anti-gay enforcement, and also some military reports discussing the problem of gay servicemen at mid-century. And so most gay histories are very much set against the backdrop of this type of state regulation, but I really found myself interested in the operations of state surveillance and state regulation itself, how legal institutions thought about gay life and how they shaped gay life. And second, at this time, I was really starting to become influenced by a lot of writing in the sociology of knowledge, SDS, history of science. And then I went to law school, which gave me more of a perspective on judicial dynamics. And so that really made me interested in the internal operations of legal and police institutions and how knowledge is constructed and transformed within those institutions. So that's what brought me to this project. As you say, it's very much an attempt to reconstruct the realities of anti-gay policing, looking particularly at undercover enticement, clandestine surveillance, and policing of gay bars. But it looks in particular at how those tactics interacted with shifting public understandings of gay life and how those understandings reached different arms of the legal system at different times.
Mm-hmm. But so much of that seemed to be shaped by the police's engagement itself, no? It felt like the way in which the police engaged and then the knowledge that they helped to distribute ended up shaping how we came to understand gay and lesbian people during that time.
I like to think so. So I'm really glad that that argument came out. I actually should say the dissertation initially looked much more at this question of how the police relayed knowledge about gay life to the public. And that argument is still very much there in the final chapter. But one piece of advice that I got in the last years as I was revising it was there was such a rich story to tell about the interactions between the police and the courts, and that I should focus more on essentially the internal institutional debates and struggles over this area of enforcement. So certainly a key part of the story is how police officers themselves endogenously produced new knowledge about gay life, and then selectively shared that with the public or with the courts as benefited their own goals and objectives with this type of patrol.
Yeah, well, I certainly want to get to the point where we're talking about these kind of institutional fissures. But before we do, I think it's actually quite fascinating that the way you describe it, at least, I find fascinating, especially as a sociologist. You essentially describe police who are doing almost ethnographic, I won't say research, but in some ways it kind of is. They're trying to understand this population that they then want to, and they then want to use the knowledge that they gain in order to effectively kind of entrap them and get them, arrest them and process them through the system. If only for a moment, we talk about this kind of the way in which you describe this kind of ethnographic approach by which they engaged this community, and then was able to learn so much about them that helped to shape how we came to view gay and lesbian people.
Right, exactly. So one of the, I realize not everyone will take to the notion of referring to the police as ethnographers. And of course, I'm not trying to suggest that they were ethnographers in the sense that academics were, but a key part of the story is essentially how in response to the gay community's growing awareness of police officers in their midst, the gay community in the 1950s becomes really increasingly systematic and stealthy, and relies on these very effective and subtle mechanisms for sussing out potential partners, for communicating subtly potential interest in new partners while avoiding both police officers and, of course, the broader hostile public. And police officers, because they're exposed to this culture, because they're really charged with permeating this culture, develop this quite rarefied ethnographic and cultural insight into gay cruising culture. They know how gay men dress, how they speak, how they behaviorally communicate interest in bars. And a lot of this knowledge is exactly the same type of insight that's then published as formal academic sociological knowledge in subsequent years by researchers. And the key twist the book looks at in the middle is that police officers were used to police officers coming into court and claiming credit for their expertise and their insight into criminalized communities. They're used to saying to judges, we know things about these communities that you don't, and therefore you should trust us when we say that an arrest was justified or that a tactic was justified. And in this particular case, police officers actually repeatedly refrain from claiming credit for their own professional expertise about gay communities. And that's because the controversies that attend some of the police's more intrusive tactics actually make judges somewhat wary of some of these police practices. And so it's much more useful for the police to downplay the sophistication of what they're doing and essentially claim that they're simply, they're just strolling through a park or walking inside a bar and just having defendants spontaneously come up to them and make various solicitations, for example, rather than to claim credit for the fact that they're really trading in this completely sophisticated insider cultural knowledge to elicit these enticements.
I'm glad that you raised this issue because it ends up being in some ways very central to the book itself. I mean, I think you rightly described the ways that when we imagine the interaction between the state and gay and lesbian communities, we imagine this whole state coming down and being repressive. And of course, it begins with police, but it doesn't end with police. And you complicate that story a great deal. Can you share the complication? You make essentially three major arguments. Maybe you can share that complication while describing those arguments that you make.
Yes, I see the book as making three core arguments, and the first is exactly what you've just described. I see the first argument is really about disaggregating the law's interaction with police groups like gay men. And so, I mentioned that histories of gay life tend to be written very much as these ground up stories of resistance and community building. Policing hovers in the back, but it tends to be portrayed somewhat monolithically as something that commanded the shared essentially devotion or commitment of police officers, prosecutors, and judges. And my argument instead is that actually anti-gay policing at mid-century was a site of profound contestation among the different arms of the criminal justice system, reflecting a variety of political, institutional, and pragmatic incentives. And so judges in particular really took objection to a lot of these police tactics, both the laws being enforced, but primarily how they were being enforced. And they developed a range of often creative ways for resisting the ensuing charges, ways that sometimes led to really beneficial results for individual defendants, but sometimes actually perpetuated and entrenched really problematic police practices as well. And so one key argument is essentially that the police's campaigns didn't just respond to the ebb and flow of political pressures or shifting ideological commitment to the regulation of sexual difference, but also reflected these really less visible institutional debates about the administration of justice, of essentially the morality of criminal laws, the limits of ethical policing, and the role of the courts really in trying to impose their views of either on the police. Yeah. And the second argument has to do with the intersection between policing and public understandings of gay life. Essentially how different ways of knowing about same-sex practices shape the possibilities of this type of enforcement. And the key here is that the mid-century wasn't just a time of great disagreement about the value of vice enforcement, but also about the nature of same-sex practices itself. On the one hand, you have certain common stereotypes that are increasingly shaping public understandings of gay life. On the other hand, you have all of these professional authorities, sociologists, psychologists, empirical researchers, who claim essentially unique jurisdiction over questions of sexual difference. And my argument is that legal battles over the policing of gay life were a critical arena for determining both the relative authority and the ultimate legacy of these different types of knowledge, both a site that brought the power of the law in deciding which bodies of knowledge about gay life were deemed authoritative or compelling, and also one where their impact was often unexpected. And one thing that I look at throughout the book is how certain bodies of knowledge that are typically celebrated as progressive might actually have regulatory effects within the legal system, and some that are remembered as really homophobic or corrosive actually have more liberatory effects. And the final point, just briefly, has to do with the politics of knowledge in the administration of justice. And so it's building on both of these prior points. The argument is that in this context, both of deep contestation about the value of vice policing and shifting understandings of gay life itself, the vitality of the police's anti-gay campaigns hung in key part on what I refer to as epistemic gaps between various arms of the legal system, essentially the system's ability to maintain at the same time multiple competing understandings of gay life. So police officers, as we discussed, developed really rarefied insights into gay culture, and they relied on those insights to facilitate their arrest. The effectiveness of anti-gay policing in the field really hung on this expertise, but they didn't come to court claiming credit for it. Instead, they essentially allowed judges to rely on their own, often outdated paradigms of queer practice. And frequently it was the divergence between those two understandings that actually led courts to approve certain controversial police campaigns. And so in this sense, the project of anti-gay policing didn't just reflect the system's disagreements about the wisdom of anti-sexual enforcement, but also certain lingering disagreements about the very thing that was being policed.
Mm-hmm. Well, it then raises the question, what makes them have such different views? So why are the police, I mean, the way it's described, on some level, they're actually actively engaged in it. They really get into it, and some officers especially really get into this. So a kind of an almost full embrace, not completely. Some officers are offended by this. I actually see a continuum. Prosecutors might be somewhere in between police officers,
exactly right,
judges, and prosecutors maybe the newer ones are just really interested in building up their wins, and so they're willing to do this. But it does sound like as they mature and are less concerned with that, they become a bit more maybe offended by some aspects of it. I will let you describe. And then judges seem to be far more questioning, again, as you point out, not just whether or not we should be doing this, but certainly how we're going to punish these folks. And what might lie behind homosexuality in and of itself. What is it that we're talking about here? Why the differences? Is it about the positions they hold? Is it about the self-selection into these positions? Can you share more about, so sociologically speaking, what makes these groups so different that they seem to be taking somewhat different stands on this issue?
So I think that's right. I think in part it's demographics. I think in part it's the unique institutional pressures of where these figures are located. So I guess maybe it's easiest to contrast judges against police officers. So first, judges are more highly educated. They're generally coming from slightly higher socioeconomic classes. And it is the case that the post-war years are witnessing a gradual liberalization of public opinions towards sexual difference, particularly among the more educated classes. So partly, I think, judges stand within that cultural shift. Judges are also, I think, less likely to buy into certain blue-collar ideals of hypermasculinity that drive a lot of antipathy to same-sex practices among the police. So I think that's also a really key difference with police officers. Beyond that, there are a couple of essentially institutional incentives that judges have to push back on these forms of enforcement in the way that officers don't. One question I actually got from some legal scholars wasn't why are judges so lenient? It's why do police officers care so much?
Yeah.
Why don't they all think that this is a waste of their time? This is the era of police professionalization. Police work is being split into these increasingly specialized units. And I think at a certain point, the mission essentially starts to determine or to shape police officers' sense of the importance of their own work. If they're being instructed to go into the field and do this type of work, and if the fastest way to essentially meet quotas in those jurisdictions that will admit or suggest they might have quotas is doing this type of work, police officers start to see it as more important than I think some members of the broader public, and certainly judges. Judges, on the other hand, are dealing with overflowing dockets that reflect a variety of cases. And I think judges are more in a position to recognize this as an especially petty part of their dockets and to recognize themselves as having some discretion in pushing back. At a certain point, a vice officer isn't going to be able to say, I don't want to do any undercover work, but a judge has certain tools for essentially quickly getting rid of enticement arrests. And this is the case against gay men, also against sex workers. So it's general pushback against certain forms of morals policing. And I also think that there's a certain an element of exposure. So first, I think judges sympathize with a lot of the men they're seeing. So a lot of the defendants that are being brought into court on gay-related charges, they're white, they're middle class, they're highly educated. A lot of them remind the judges of themselves or of their own neighbors. And I think this is a really key part of the story, that part of what's driving sympathy is the unique demographic of this particular form of enforcement. And judges also, unlike police officers, are exposed to these much more humane, sympathetic stories about defendants. Judges get to see the character witnesses that are brought in court to defend the character of these men, while police officers are more likely to encounter them solely in the posture of target of enticement or denizen of the urban underworld as they see it, rather than seeing the other parts of their lives that judges are seeing. And finally, I think judges are more exposed to the influence of psychiatry in these years. So a really unexpected part of the story to me was the role of psychiatry and specifically certain professional infrastructures that are erected by what we typically think of as deeply, deeply conservative developments, the sexual psychopath laws in the early 1950s. Psychiatrists, and particularly state-funded psychiatrists, really, really prevail on judges to dismiss these cases. If you accept, as judges and certainly psychiatrists did, that homosexual desire is essentially, it's a latent condition that can pop up in anyone when they're sufficiently stressed or overwhelmed with other professional or personal concerns, then it appears to those judges that police officers they're not just identifying potential offenders, they're actually breeding sexual deviance by manipulating these vulnerable men to give in to impulses they would otherwise never have given into. And so in some cases, in Detroit, I have this case study of the director of the psychopathic clinic actually personally visiting the trial judges and saying, I think that essentially this is an extremely moral form of enforcement. I think it's contributing to the problem of homosexuality in Detroit, and I want you to throw out these cases whenever you see them. And so I think that that also is the extent to which judges were influenced by psychiatrists, and the extent to which certain psychiatrists had just a professional line to the ear of the courts makes judges unique as well.
So these men weren't criminals; they were sick, and we should have a kind of sympathy towards them. How did judges respond to non-white, non-middle class, non-kind of male, very male, traditionally male-presenting men?
Yeah, so that's they didn't respond to them as sympathetically. That's certainly the case, although it is the case that a lot of judges adopted certain systemic approaches to throwing out these cases, and sometimes inspired prosecutors to also adopt office-wide procedures for throwing out cases that did often benefit men who weren't necessarily the most impressive, wealthy, sympathetic defendants in judges' eyes. So the book focuses, in key part on cases that have to do with white suspects, partly because I think this is a rare defining feature of this law, partly because I'm looking very often on judicial encounters with policing. And so these encounters are often driven by wealthier defendants who have the resources to mount defenses, often through the appellate courts. It's every now and then I try in the book to have what I hope is a really memorable, appalling anecdote of the way judges might not be similarly treating, and prosecutors as well, treating people of color. So, there's a case where one judge is essentially he's adjudicating a Fourth Amendment challenge to a clandestine surveillance post, which on the one hand captures a white defendant, on the other hand captures two defendants of color, and he throws out the evidence against the white defendant, and he doesn't throw out the evidence against the defendant of color. So I think absolutely there's a concern that some of this discretion is very, very specific in the defendants it's targeting. It is also the case that I think some judges really did believe, for example, in the psychiatric theory of sexual difference. And so certainly there are also stories of judges, for example, pardoning legal fees or court fees for poor defendants because they genuinely believe that money would be better used on medical treatment. So I don't think that this form of judicial discretion is purely a pretext, essentially, to acquit or dismiss charges against those defendants that judges most identify with. But I think it's absolutely the case that in the fault lines in how they exercise discretion, I think there's difference in how they treat different categories of suspects. And I think the reliance on medicalization and the language of disease to forgive certain forms of criminalized conduct outside the context of sexual difference, but also very much within it, is itself racist and is itself classed. There's some great work on how the rhetoric of mental illness was used to explain away and forgive certain non-conforming sexual conduct among middle-class bourgeois white people, while similar conduct among poor communities of color were traced back to some cultural pathologies. So I do think that at a certain point that rhetoric is it's pervaded it's pervaded throughout with certain racialized and class-based differences in how judges understood particular individuals who came before them.
So you make it very clear that even if judges did try to reduce the kind of harms that were done to especially gay men, it was still a very repressive kind of regime against gay and lesbian communities. Of course, it seems like police and prosecutors would be responding, though, to how it is that judges are the kind of leniency that they engage in. It's hard to imagine that police and prosecutors, to some extent, aren't maybe a little upset about this, the way judges are being so light, and would be responding in kind. How did they respond? Both police, but also prosecutors.
Yes, absolutely. So, one of I think perhaps the best evidence of the systematicity of what I call judicial lenience, although it's absolutely the case that this lenience only went so far. But I think part of the best evidence is the resentment it inspired among prosecutors and among police officers. So prosecutors tend to respond by complaining in private, but essentially adopting screening mechanisms and charging patterns that accommodate judicial humor. So in Detroit, the prosecutor's office institutes essentially a practice of having a senior prosecutor screen all charges that are brought by junior prosecutors, precisely to weed out overzealous junior prosecutors who are bringing too many of these cases. In LA, the city attorney announces that essentially that the city no longer charges first-time offenders with the sort of the relevant statute that would carry with it certain stigma, the stigmatic collateral consequences of a sex-based offense, including sex registration requirements. And he openly says that he was not interested in adopting this policy, but his office found that they simply could not get convictions if they tried bringing these charges against first-time offenders. And I think it's in practice, there's evidence that they really often reduce subsequent offenders as well. So that, prosecutors don't have, I think, too many ways of responding to judicial pressure other than essentially offering to reduce charges to just clear these cases from their own desks. Police officers do have more options, and some of those options, as you read, are very much not what judges have in mind when they're trying to push back on these practices. So sometimes police officers, first of all, they develop some remarkable sensitivity to the humors of individual judges. So in Detroit, police officers will often essentially modify their arrest practices around the preferences of the particular intake judge who's screening or who's overseeing cases that month. And if a judge is known for essentially pushing back on gay solicitation arrests less so than arrests of sex workers, then they're going to focus on gay men, and then they'll switch to sex workers the next month. Some police officers just preemptively start arresting gay men on lesser charges like trespassing. So they're not actually arresting fewer people. They're just essentially avoiding the hassle of having to then debate the propriety of this particular charge. Some police officers avoid the courts altogether, and they turn to more informal mechanisms of harassment, essentially just dispersing gay men in parks and in bars and in streets, or just relying on their presence to intimidate gay men. And some police officers turn to much more violent means. And so, I certainly don't mean to imply with the book that police officers needed some invitation to resort to violence against marginalized communities like gay men. But it is the case that multiple commentators at the time remark on the fact that vice officers justify their brutal treatment of gay men as a response to essentially judges' lack of cooperation in properly processing cases. So this provides a moral justification for this type of police violence within the police station. And so, in that sense, some of these patterns, which I think are among the most resented, rightfully, the most resented patterns in police confrontations with gay men, these patterns of harassment and abuse are very much not the result of courts giving police officers a carte blanche in how they treat gay defendants. They're very much the results of essentially police resentment over the court's intervention in their arrests in court.
Mm-hmm. So this actually reminds me of our current moment. And I wonder to what extent you have been thinking about some of these things. The thing that comes to mind immediately now for me is the non-prosecution of a set of low-level offenses that a number of DAs across the country are engaging in. And so one of the questions that I've been asking myself, and I actually I'm actually thinking about doing some work to study this, is what impact this has had on police behavior. Like, so initially, I think I imagined, well, if they don't, if they can't prosecute these, then they'll probably figure out some other things to charge people with that might be, I wasn't sure. But after reading this, I'm thinking there are a whole host of ways that they could respond, especially if they're feeling resentful. And I do think police in the current era are kind of feeling a bit resentful by the move towards non-prosecution of these 15 or so low-level offenses. What have you been thinking as a result of what you've learned from your work, given what's emerged in this current moment?
Right. So that's a really it's a really great question. You know, typically when I think of the relation between the story I tell here and essentially, you know, the policing of petty morals offenses today is actually more the question of essentially why you don't see the same judicial pushback. Yeah. You know, and I think and I think there are a lot of reasons for that. So one is, I think, you know, in some areas of enforcement, like anti-solicitation arrests, I actually wouldn't be surprised if more of this pushback is happening than we realize. There's not a lot of scholarly attention to a lot of these forms of policing. But I think we have pretty good evidence that judges don't resist drug-related offenses, for example, in the same way that they resisted. And part of that, you know, I think in some ways, the case of anti-gay policing is a perfect storm, where you're dealing with a victimless moral crime. You're dealing with sex-based enticement, which judges are particularly offended by. There's this concern about the medical aspect. The judges don't want to contribute to essentially what they see as a medical problem. And of course, as we discussed, there's just the demographic that I know in the introduction that I in key part see the story as a story about the policing of whiteness. And essentially the amount of creativity and flexibility that arises within the judicial system when judges are confronted with defendants with whom they sympathize, who remind them of themselves or of their neighbors. And it's simply, at a certain point, it's simply the case that judges have essentially bought in more to the legitimacy of drug charges than they did they bought into the legitimacy of anti-gay arrests back then. But I think this question of, you know, essentially non-prosecution agreements that are negotiated outside of court is a really interesting one. And a new one. I'm not a sociologist, so I feel like at a certain point, everything I know here,
you are, Anna. You might not have been trained, but
I know.
A sociologist I know would love your book because it feels so deeply sociological.
That's
what makes it brilliant.
That's incredibly gratifying to me. I would love to be an honorary sociologist. You know, I think there's a lot of, and this goes back to Jerome Skolnick's work. I think there's a lot of research that to me makes a lot of sense about about police resentment at essentially judicial second guessing of their own professional judgment and their own expertise and their own discretion in the field. And I think that I imagine the same dynamic would apply to something like non-prosecution agreements. If police officers feel that, you know, naive and Pollyannish outsiders are coming in and telling them how they ought to be dealing with certain cases and what they see as certain problems of you know, criminal patterns, I don't think police officers will necessarily essentially be happy to prostrate themselves to that, you know, to that authority outside the police station. I think, you know, police professionalism and police expertise and police self-conceptions as expert law enforcement agents are something that I've worked a lot on, and I'm working on now. The book has been set to the side. You know, I think we're increasingly in an age where police officers see themselves as professionals who are worthy of respect and who are worthy of deference. And so I think that identification of officers as professionals will fuel resentment and resistance to these types of policies that are really negotiated outside the police department. So I certainly I could imagine a similar dynamic, as you see here, where police officers who have been used to a particular pattern of enforcement and therefore have, of course, convinced themselves that it's important in the same way that vice officers convince themselves that solicitations or enticing solicitations in gay bars is important. They're going to continue to think that they were doing important work before, and therefore it is their job as the enforcers of the law and as the keepers of public safety to continue doing what they can to push back on those activities.
I'm glad that you mentioned judicial pushback, because one of the other things that you mentioned about this particular context between the 30s and the 50s is that the judiciary didn't really hold police officers in very high esteem. I mean, they were beginning the process of professionalization, but they hadn't really gotten there quite yet. And what they had left behind was just a kind of a history of incompetence, and they were dirty and all sorts of other things. So judges had a good reason to be concerned about this, suspicious about them, worry about whether or not they were doing things correctly, competently, ethically. And so that contributed to their willingness, their ability to be a little skeptical about how they ran things. And that, I don't think we're in that moment. Clearly, police officers are viewed as a very kind of professional organization or agency, and judges seem to have a lot of deference. But it might be possible, as we learn more about the levels of brutality that some face because of all of the videos, et cetera, that might change. Might we be entering an era where judges might not take for granted the high standing of police officers, generally speaking, and then enter these interactions with a bit more skepticism?
I hope so. I think I'm a pessimistic person at heart. So I hesitate to say yes, because, and so this relates to a lot of my work outside this book as well. But essentially, I think perhaps the through line in my work is essentially judicial relationships with police agencies and judicial views and deference to police. So I do one project that actually, this was my job market project. So when I put the book aside, was essentially looking at how why judges might be more inclined to accept on faith the notion that police officers have unique expertise, not just because they might just want to defer to police officers, but because the context in which judges encounter police knowledge might inflate the value of that knowledge. So I do think it's the case that judges, there are certain structural biases shaping how judges encounter police knowledge that incline them to think more highly of the police. And this includes many things. It includes sort of the rise of expert witnesses and judges seeing police officers as experts on the stand, which is actually not necessarily a very high bar, but once you've qualified someone as an expert, you begin to be used to essentially perceiving them as such. It includes, the sexual selection bias and suppression hearings, where police officers often claim expertise in context where, lo and behold, their judgment has been vindicated, because in this particular case, there was, in fact, evidence of some crime. So I think that, and I also think judges are, as in some sense, fellow servants of the law. I think judges encounter, judges lecture at police academies, they attend police academy graduations. And at mid-century in particular, police reformers really targeted judges at their conferences. And some of them very explicitly said that, inviting judges to our professionalism-related conferences was a very useful way of having a two-way exchange of information. Right. So if that's the case, then it would figure that judges now being exposed to more just essentially unavoidable evidence and really unforgettable evidence of police brutality, police misconduct, just errors in police judgment, that should or would have an effect. I do think that, realistically speaking, there are at this point also so many other grounds for judges to defer to police judgment. And that includes pro-prosecution biases. It also, like actually in this case, it includes just wanting to simplify their own dockets. So I hesitate to say that it's as easy as presenting judges with evidence of their mistakes and getting them to change, to change their opinions. But I'll stop there.
I appreciate it very much. The point that you're making, not that you're stopping. So So for those of for folks who are not necessarily interested in the history of anti-gay policing, what kind of takeaways could they have above and beyond the specific case that you want them to leave the vice patrol with? Sorry about that.
No, absolutely. So, I see this as a case study of the hidden operations of law enforcement against the marginalized group. And so, I like to think that case study has implications for law enforcement more broadly, for historians, but also in an ideal world for people who are engaging with policing outside the academy today as well. So one, I do think this story is a really powerful reminder of the remarkable discretion and flexibility of lower level legal actors in shaping the administration of criminal cases, especially petty charges. As we've discussed, they don't necessarily exercise that flexibility. But I do think that the potential creativity and power of trial judges to push back on charges, and also the really unique institutional pressures that shape how trial judges interact with the police. These aren't just, I think, neglected sometimes by historians of sexuality, but I think by legal scholars as well. So, I think it is common still to discuss judicial views of the police, for example, by largely citing Supreme Court cases and appellate cases. And so I like to think that this book really shows the limitations of that approach and the importance of institutional specificity, of recognizing the many really unique pressures that shape how judges interact with the police. Second, I think that argument about the transformative effect of legal institutions really illuminates debates about policing and about the law beyond the case of vice patrol. I think there is a common tendency, building on some really, really brilliant histories and studies, to see legal processes and judicial reasoning as reflections of broader cultural trends. So to shift judicial rules or judicial reasoning, you first have to shift judicial cultural discussions outside of the courts. And that's often the case, but it's not necessarily the case. Given the unique pressures and demands of the legal process, cultural developments often play one role in public debates and another role in court. And I was, there's an example of this right now with the trial of Derek Chauvin in Minneapolis, where I think the growing recognition of police misconduct as systemic, which really fuels demand for change in public conversations about the police, also ironically stands at odds with certain judicial processes for getting legal accountability for individual police misconduct. And these processes really reward more of a bad apple approach. And that's certainly not to say that sort of the courtroom effects of these debates outweigh the public value of more sophisticated understandings of police misconduct. Just like I'm not saying that on net, the medicalization of homosexuality was good versus bad. But I think it is to emphasize the importance of accounting for the downstream effects of certain cultural developments and of public discourse in a system that gives courts really outsized power in shaping the lives of certain regulated individuals or police groups. So I think that is something else that I've also really thought about since working on this book, and hope that might have some interest to people beyond history of sexuality. And finally, very quickly, I'm sorry, my answers are all way too long. I think the book has some lessons, and this is maybe a little bit more speculative, about how legal systems treat marginalized groups, which is to say groups that are regulated, but that also aren't very well understood by those who are doing the regulating. So a key focus of the book is how Vice Squad's campaigns rested on these persisting gaps between how police officers and judges understood gay life. And certainly anti-gay policing is not the only pocket of law enforcement that targets marginalized and misunderstood groups, or where police officers might develop unique insights into police communities, or where police rely on really controversial tactics. I can imagine the same applies in the regulation of sex work, in anti-terrorism investigations, in policing of gang activity. And so here too, judges often rely on the police's representations of these communities to decide whether particular enforcement tactics are reasonable or lawful. And so without having the answer right now, not having done the on-the-ground research myself, I hope that the book invites us to examine how certain continuing pockets of ignorance in the legal system, how the police's failure, intentional or otherwise, to communicate their full understandings of police communities to the courts might really shape judicial reasoning in a way that obstructs potential checks on police power.
Yeah, absolutely. I mean, when I read Vice Patrol, I not only did I gain an understanding of the history that I didn't have before, and marveled at some of the insights that you provided. I had not thought about the kind of fissures that exist among the different agents. It had me thinking about not just other issues within that time, but also how we can import the understandings that you bring to the fore to this moment. And I think I'll continue to think in these ways. So I absolutely loved reading your first book, and I can't imagine that this won't be so well received. It's incredibly well researched. It's extraordinarily well written. It's an amazing first contribution in terms of a book to a set of bodies of research. I love it. I hope that other people will take it up and read it. Vice Patrol: Cops, Courts, and the Struggle Over Urban Gay Life Before Stonewall. Thank you so much, Anna, for having this conversation with me.
Conversation.
This is incredible.